now.
What power does that referendum decision have in the law?
The referendums are the voice of the people.
Absolutely.
That is the law of the land. It is asking the people to amend or repeal a part of the Constitution or add to a part of the Constitution of the Commonwealth with your approval. And it goes state by state, and then it's looked at in a whole of Australia context. And not one state of Australia said yes.
Sorry, clarify, excuse my ignorance, but does that just mean that all states, state laws just don't have any effect? Is that what you're saying?
In pure law, yeah.
No force and effect.
So we have one.
No force and effect under that referendum.
So if you refer to that in a court of law that is trying to apply those state laws to you,
theoretically, the court of law that you're going to be applying this to is a court of your peers.
In Victoria, absolutely valid.
Okay, when it comes to a single judge, okay, we're talking a different entity here. Just if we could, please, Kelvin, we'll go to the heading of Chapter 3. We really need to establish this differentiation in the court system. And it really comes crystal clear when you just see the heading of Chapter 3.
That 144?
Not for the moment, but yeah, we'll just go to Chapter 3.
Can I just elaborate on that point? Would you say it's safe to say also that crimes that are known to death for you is also struck out due to the fact that you said? There's still a Victorian law.
You know, we've got to look at law and look at it in the light of the Commonwealth of Australia Constitution. Where there's the consistency, yes, and it marries up also with the laws of England, of which the Constitution of the Commonwealth does. Then it must be considered law, because a lot of these laws have been tried and tested in the courts and through the parliaments over hundreds of years. So this is the voice of the people that is taking effect to create this body of law. So it's imperative that we understand where inconsistencies lie and how to recognise an inconsistency.
But what I'm saying in regards to that referendum that you're referring to, will it purely in law speak also wipe that out?
Yes, it does. When you, the people, use that as an interpretation of what you understand when you read that. I'm giving you my interpretation, and I'm giving you interpretation from people here that have read what I'm talking about, and they extrapolate that same interpretation. Okay, it's crucial. It's written in straightforward English. You don't have to be a lawyer to understand this stuff. You don't have to understand Latin.
Of local law is completely true on me. I'm not sure.
Yeah, but I've undone councils quite a fair bit in the past under their own act. Section 111 of the Local Government Act here in Victoria, subsection 2 and 3, pretty much says that any law created or any bylaw created by a local government cannot be inconsistent with any other act. Straightforward. Do we understand from what you've learned tonight what I've just said? Local government. Any council, any...
Commonly referred to.
Yeah, section 111 says no inconsistencies can be brought about by that local government. Okay. No inconsistencies with any other act. It doesn't say any other state act. It doesn't say any other... It says any other act.
That's a local law.
So it's local laws, and this is the problem. A lot of councils are exercising local laws that are way outside of their jurisdiction, but again, they're relying purely on ignorance of the general public to get this through. And it's usually in the form of a fine. Just pay us, just pay us, just pay us. Wow, you know, these people are making the mafia look like they're in kindergarten. So, the heading of Chapter 3, what's it say? Does it say judiciary? No, it doesn't. Do you know what the word judicature means?
What does it mean, Darryl?
Means? I'm so glad you asked that question. It means. It means a jury and a justice. A jury and a justice. What's a justice? I hear you say. A justice is a volunteer, a trusted member of our community, JP, who sits and adjudicates that hearing.
Not someone appointed by the state.
There's a conflict of interest when you get an administrative representative who's there in the interests of the state. And here in Victoria, that wrong was brought about predominantly in about 1988 under the Premier John Cain, when he changed the Court of Petty Sessions into the Magistrates Court, and he put magistrates over and above JPs. Section 26 of the Open Acts Interpretation Act, Commonwealth, says that the JPs have a judicial authority. You get two JPs together, you've got a court. You can get together a notary public, and that's also a court.
Is this still in effect, or is that?
Yeah, absolutely. But unfortunately, the Commonwealth doctored Section 26, and they said that a magistrate can overrule the ruling of two JPs. That doesn't make sense. Okay, and again, it's inconsistent with Chapter 3. Judicature. Judicature.
That point could be defended in the High Court.
Oh, absolutely, but where is there a High Court? Okay, we lost our High Court in about 1952 under Menzies. Okay, now, in 1952, Menzies lost the Communist case. For those who studied law, that was a sort of landmark time, and Menzies, in retaliation to the High Court, he installed a rule which is now reflected in all of our courts, and it restricts our access to the courts. Okay. So they brought this rule in the federal court, I know it by heart. It's Rule 46, Order 7, and it's either a judge in chambers or a registrar can read your writ, your presentation, for filing. And if that's embarrassing to the state or the Commonwealth, he'll just say, no, we're not filing that on the basis that it's vexatious, frivolous and misconceived and an abusive process. And there's no establishment as to why, and this is where there's a wrong. Okay, and this is a breach of Henry 4, 2 Henry 4, which is an imperial law which allows and guarantees our freedom of access to the courts of judicature. Okay.
So, where are you pulling that definition from?
Which one's
Judicature.
Judicature comes out of the Judicature Act 1873 and 1876 here in Australia. Also Queensland. And it's important, there are some states in Australia who still have this pure law as part of their system of law. And we can use any law, like if there's a law in Western Australia that's convenient for our particular case, we can use Section 118 of the Commonwealth Constitution Act, which I read out earlier before the break. Full faith and credit. Full faith and credit shall be given throughout the Commonwealth. Okay. So you can take a state law from Western Australia and use it here in Victoria, or a Queensland law and use it here in Victoria. Full faith and credit. So there's no discrimination anywhere in the Commonwealth of the laws, as long as they are consistent with and are subject to the laws of the Commonwealth. Okay. So, and this is what the judicature must adhere to. Now, in Section 71 of the Judicature, it describes the court system, and when I first read it, I admit I just thought this was a description of the High Court, but it goes further when you look into it very deeply, and I said earlier and reinforced this, each word is important. So the judicial power of the Commonwealth shall be vested in the Federal Supreme Court to be called the High Court of Australia, and in such other federal courts as the Parliament creates, and in such other federal courts as the Parliament creates. All you need to do is establish that with the court. I am here in federal jurisdiction. I am here in federal jurisdiction. When you use this law, when you use any law of the Commonwealth in any law of the state, that must be established. Federal jurisdiction. The High Court shall consist of a Chief Justice and so many other justices, not less than 2 as the Parliament prescribes. So, what does the High Court made up of? There's 7 in total, one representative from every state. But according to Section 71, there's got to be a minimum of 3, including the Chief Justice. Right, so when we see a High Court ruling that's been given by one judge, is it a High Court ruling?
No.
No. That's right. There's been no amendment made to Section 71 to allow for a single judge.
When would you see that? When would you see an HCA that's actually do a single judge? Does that happen?
Oh, absolutely. In Dooney versus Henry 2002, there was to establish GST here in Australia. They had to get over this very awkward section of the Commonwealth of Australia Constitution Act, Section 55, which has been argued many times since 1917 predominantly, regarding taxation. And it was a direct abuse of Section 55, a 10-year-old could read established. Yeah, most. And in Dooney versus Henry, a single judge said, when I read Section 55, I don't see there's any correlation between the GST and this section, so I'm overruling any application to strike the GST.
Yeah, because GST is not a tax.
It's not a tax.
It's a goods tax and a services tax. It's not a tax.
So when we read Section 55,
No, that's me to figure it out.
it's there. Laws imposing taxation shall deal only with the imposition of taxation, and any provision therein dealing with any other matter shall be of no effect. Laws imposing taxation, except laws imposing duties of customs or excise, shall deal with one subject only.
What does shall mean, Carl?
Shall, must,
Is fact.
is, shall, must deal with one subject only. When you go to the Quick and Garran, they devote a page and a half explaining and reinforcing if there's a breach of that part I just read out, that one subject, you have a problem on your hands of government overstepping its authority.
And the High Court.
And the High Court upheld this misbehaviour. Not in Resch versus the Commissioner of Taxation, 1943, that particular section of law was in front of the High Court, and they said, yeah, you cannot put a duality of subjects on any one tax. That's correct.
Well, that was way before GST. That was back in 46 or something.
1943.
42.
Yeah, 1942.
Why was established era and why is GST still around?
Because it was a political need. Like I was trying to explain earlier, in 1629, King Charles wanted to bring in tax, compulsory tax to the people of England called the tonnage and poundage tax. Now, in order to implement that tax, he sacked the Parliament. He got rid of the Parliament. He rose star chambers. He empowered sheriffs and bailiffs to roam throughout England to collect the tax. And for 11 years in England, it's known historically as the 11-year tyranny. The Long Parliament is also another term that's used for that period in England. And in that period, there was no justice in England. And in 1640, a group of people, of which the most famous name, I guess, would be Oliver Cromwell, pretty much dragged the king in and forced him to assent to what is known as habeas corpus. habeas corpus is the real